Hello, everybody. I'm getting myself sorted out here. Sorry, 1 minute. Hopefully everyone has been having a lovely weekend. It's been a busy one in my neighborhood. So, yes, good evening. Hello, everybody. Hello. All right, here we go. I've really got to get myself sorted out. Where did I go? Oh my gosh. There is an interesting case that I want to, oh, here it is. It's right on top. Hello. All right, here we go. Only the most professional of live streamers. Everybody, as you know. Okay, we're back. Here we are. Hello, Kimberly, Mo Girly Girl, Alice, in Wonderland. June, hello. Betharoni, hello. Lisa, welcome. Hi, Cynthia, Michelle, hello. Willie B, good to see you. Welcome to class, everyone. Good to see you. I'm very glad that, and keeping my fingers crossed that this week I'll be able to do my scheduled Sunday, Tuesday, Thursday. So I'm very excited about it. I love the nails. Thanks. Yeah, I'm kind of in the I'm in the middle of a nail project, so these are pretty temporary, but I thought, no, they'll go okay for tonight. Oh, thank you, Achilles. Thank you. Yes, glad to see everybody. Yes. Hello, Heather, J Jack. Hello, Kathy. Welcome in. Casey, yes. Oh, I'm so glad. I'm glad you caught us. Nancy, welcome. So I will be going here on almost exclusively over here on the tube on Sundays. That's my chairs, kind of. I gotta squeaking everybody. So Sundays, Tuesdays, and Thursdays. Man, I am just all over the place tonight. At 7 p.m. Central. So those will be my, my show times. Now, if something is breaking, like breaking news, I hate to use that phrase, but if something gets handed down and I want to go live immediately, that quick immediate live, I will be doing that on TikTok because TikTok is still in play for, 60 days, I guess. So we've got an order we're waiting on in the JGG case. So as soon as that comes down, I will go live and read it on TikTok. But for my lives here, I will also read it here, but I will be doing just scheduled Sunday, Tuesday, Thursday nights. And I also found that trying to get it during the day was a bit too much for me over here, everyone. So, oh, you went to a protest? Oh, we love it. That's fantastic. Oh, that's so great. Oh, white nail polish is your favorite. Oh, I like it too. I like it. It's nice and fresh, right? I can't keep it all straight. Oh, I know. Well, it's interesting. Some people, again, as a moment to complain about the TikTok situation. Some people are saying, well, Congress passed the law and the Supreme Court thought the law was fine, and then, we should be following the law, blah, 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 blah. And to that I say, yeah, well, I think they were wrong. So I think the Supreme Court was wrong. I think their ruling was wrong. So if there's kind of a stopgap or a little do-si-do around it, I'm all right with that. Until someone much more powerful than myself steps in to correct the situation. TikTok blocks of bots when the orange man went into office. Oh my gosh. Yes, I think we all had things we were doing until that moment happened, and then the whole thing changed. Suspended the attorney for not lying to the judge for the immigration case. Yes, I have. I did hear about that. And, that's the thing. There are, at this point, I've heard, from what I've heard and from what I've seen, there are hundreds of law firms around the country that are just full support of any attorney who is trying to uphold their oath to the Constitution and not be bullied. So we're starting to unite over here in the legal field. because it's just out of control. It's out of control. It's out of control. It's a lot. In such a bad spot. Well, of course. But that's a spot that we have, well, that most of us have already been put in one way or another. When you're working in the legal field, you work for a boss, but you also have to work with your own ethics. And so sometimes it's okay to just get swept up in what the boss wants you to do so you can make your moolah. But many of us, the majority of us, in my humble opinion, our oaths are sacred. So we just are unwilling to cross that line. And that really is the majority. Again, you'll get a few, we'll get some here and there that are kind of like, but the vast majority of us, one of the reasons we became attorneys is because we wanted to work within the confines of the Constitution. So, Bush spoke out. Okay, I saw that Obama has been speaking a little bit. That's interesting. I thought that was great. It was time. Sometimes my timing gets thrown off because TikTok is so fast, everybody. And so I'm all over TikTok and I'm like, blah, 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 blah. And then I step back and the whole rest of the world's like, we're about 3 days behind you. So I've got to kind of slow it down again. Slow it down. Oh my goodness. Yeah, it's a lot. It's a lot. So just checking here. Hello. Yeah. So tonight, everyone, I thought we could just go through, I've just been trying to go through my stacks of paperwork here because there's so much. I'm reworking the closet docket. So I'd hoped to have it done, but I only made it through about 130 cases. And so I've got about 40 cases left to put into the docket. So we'll have to do that Tuesday. But I am updating it. Now I think it's a good time. We went before under the categories, right? So the DOGE lawsuits, the habeas lawsuits. And so now what I'm trying to do is put them in order of what's next. Like, what are we waiting for? Are we waiting on an order from a court? Are we waiting for the oral arguments, the appeal, and so on? So I've had to restructure, move things around because we're far enough into the lawsuits now that we're going to start seeing some action. And we've got, Supreme Court cases. We had our first one go up and then come back down again. Well, I mean, we had Dillinger, but come back down and need to be implemented so that it went forward. So that's quite a bit going on. A bridge too far. Well, yeah. I mean, oh my gosh, they're asking too much of us, and not all of the attorneys are like they're kind of, schwarmy ones, as I like to put it. 132 cases. Yeah, I couldn't get the last ones on the docket. It was too much. I couldn't update it. So I will do that one on Tuesday. For the Constitution be required coursework. Yeah, I agree. So something I came across as I was going through this, new organization of the closet docket was I found this. Let me grab a pen here. I found. What did we do? No, that's not the right one. Man, I just can't even make choices today. I'm decision fatigued, everybody. Fatigued with the decisions. It's been too many. So this was the filing here recently, and I didn't even realize it had been filed. But this is in re Elon Musk in his official capacity, and he's got a petition for a writ of Mandamus to the U.S. District Court for the District of Columbia. So I thought this would be really interesting to take a peek through here, to take a look at what a writ of Mandamus is. Now, we may start seeing quite a bit more writs of Mandamus being filed for. A writ, of course, is a way to get in front of a court, and then we have different things that we're wanting to do. So Mandamus is saying you're asking the court to order someone to do something, essentially. This writ of Mandamus was the issue in Marbury versus Madison, right? Everyone remember Marbury versus Madison? Just as a quick refresher in our con law reminder tonight. So yes, okay, let me make sure I'm tipped the right direction. All right, so in Marbury versus Madison, there were judicial commissions that had not been delivered. So, and again, I've done a lot of posts on it, on the Marbury case. But what was at issue, what they wanted from the Supreme Court was that the judge, the Supreme Court would issue writs of mandamus forcing Jefferson to give the commissions to the judges that hadn't received them yet. So that's what the request was. This was what the cure was for the problem in the Marbury case. So again, here we are. We have Elon Musk asking for the court here to direct someone to do something. So let's take a look and just see what we've got in here. Hello, Kaya. Welcome. So here's our table of contents, our introduction and our summary, our statement, our argument. And then we start diving into this. And we're going to see a lot more of this, again, as our cases get further down the road, because they're starting to move, everyone. I'm not saying all the cases, but there's some cases that are really starting to move through the system now. Here's the argument. The court should exercise its mandamus authority to block the discovery order against White House defendants. There's a lot of discovery being requested from DOGE. I have not seen discovery requests, this many of them, out of any of the other categories. So anytime DOGE has been involved, they're asking for very specific discovery and usually expedited discovery. They're asking them to hurry up. Ooh, and quick side note, everybody. I did today find that we had one motion to compel that has been filed. We have a motion to compel where they're saying the discovery is not being given to them, and it's a DOGE case. And so they filed a motion to compel to the court, and the court answered back and gave an order to compel to the government to give this discovery information to the harmed party. So we do actually have one order compelling discovery and a non-compliance out there, just as an FYI. So what they're saying here is that we don't want to give any information to the plaintiffs, and we shouldn't have to. The first argument, the Supreme Court's made it clear that discovery against the office of the president is reserved for exceptional circumstances and must be a last resort. So again, this is the government's brief that I'm walking us through here. B, the discovery order here directly contravenes the Cheney case and violates separation of power principles. Number one, the district court improperly ignored the constitutional burdens and separation of powers concerns that discovery against the office of the president raises. Two, requested discovery is irrelevant to deciding plaintiffs' claims. Three, the district court failed to consider alternatives that would avoid discovery. The discovery order is grievously overbroad. So that's the argument that they're presenting. Again, this is in re Elon Musk. And I believe this is the DOGE case that has been filed that Judge Chutkin is presiding over. So that case has gotten really dicey because we have this mandamus request that's been put into play. So here we go. Table of authorities here. And statute cited. And one glossary, which is the USDS here. All right, so let's go ahead and go through the introduction here. A sticky note is usually requested, right? So I can do that. I'm wondering what we should call this, though. We will call this, here we go. All right. This is a writ of mandamus requested by Elon Musk, and it's being argued by the government. So lest we forget, we have Elon Musk in his official capacity at all, which is again kind of weird, right? Because he's like, I'm just an advisor. I just look around. I'm just consulting. But he's actually filed a law question, a legal question, a petition for a writ under his own name, under his official capacity. So this status here could come back and haunt him and the administration, if they're trying to come in and say, well, it doesn't really have anything to do with it. Well, then why did he file this writ of mandamus request? Am I right, everybody? Am I right? So we have our acting assistant attorney general here, deputy assistant attorney general here, attorneys for an appellate staff here. So kind of keep that in mind again, everyone. And so here is our sticky note, and I'll get us started with the summary, and then we'll just kind of chat a little bit as I walk you through. I won't be reading word for word for this particular brief. So hello, welcome VC, good to see you. Hello Chris, hello. Oh, I just love seeing everybody coming back. Kat, Boxer Mom, welcome, welcome. Here we are then, pursuant to the All Writs Act of 28 U.S. Code Section 1651, the government respectfully asks this court to issue a writ of mandamus quashing the district court's March 12, 2025 discovery order, which permits plaintiffs in this case to take broad, intrusive, and unnecessary discovery into the activities of the office of the president and the president's senior advisor, Elon Musk. So again, this is fascinating, everybody, because didn't he say he wasn't part of DOGE? And then here he's saying, well, he's the president's senior advisor. So there's a lot of questions going on, exactly what his role is, and that's why they're requesting discovery, because they're trying to figure it out. The government additionally asks in an accompanying stay motion that this court stay the discovery order pending resolution of this petition, and the rule on the stay motion by March 26th of 2025, 1 week before discovery would be due. The district court's broadly phrased and premature discovery order raises grievous separation of power concerns. It requires the government to produce information regarding the activities of the U.S. DOGE Service, an organization within the executive office of the president and close presidential advisor Elon Musk. So again, everyone, it's like we're mining for gold tonight. Look at this. They're wanting information, so discovery in this case. This is the DOGE case that Judge Chutkin has been presiding over, and spoiler alert, it has been stayed until this gets sorted out. This is still, active and running, and the U.S. DOGE Service, which is an organization within the executive office of the president. And so if it's within that office, then there are certain federal statutes that are required to be followed by DOGE. Everyone, are you following me on that one? Because we have lawsuits saying you're organized illegally. And they're saying, well, we're not really doing anything. And then now they're putting it in a legal filing. So, again, just keep that in mind. He was said to be not affiliated with DOGE. Right. Well, exactly. And this excellent. Thank you, Boxer Mom. This filing, again, is filed in Ray Elon Musk. The other thing, too, is if he decides to step down or move away, then somebody else will need to step in on this because it's his name in the caption here. All right. The order requires the White House to provide detailed information regarding the substance of the advice USDS and Mr. Musk have provided and the process through which that advice has been formulated and communicated within the executive branch. This unusual and highly invasive order threatens the executive's interests in... I don't think they can talk about something being invasive, maintaining the autonomy of its office and safeguarding the confidentiality of its communications, and fails to accord the high respect that is owed to the office. What? So they're being disrespectful. Just writing that in there. Are you kidding me? This is crazy. Office of Chief Executive in the conduct of litigation. And then the Cheney case is the big one that they're citing here. And I've not read through the Cheney case. It's on my to read list, but I've not been there quite yet. Moves so slow, I'm afraid that it will never catch up. Oh, well, eventually, I'm like a Russian tank. It is slow, but it's quite destructive. Addressing a similar discovery order, the Supreme Court made clear that discovery directed at the office of the president and the president's senior advisors must be reserved for the rarest and most exceptional of all circumstances. So then the question becomes, how does DOGE fit in with the office of the president, and who's in charge of DOGE? Is that a senior advisor, right? So those are the questions that have to be asked. It is permissible, if at all, only when strictly necessary, only after all other avenues for resolving the plaintiff's claims have been explored, and only when drawn as narrowly as possible. The court also expressly rejected the view that the threatened intrusion on the autonomy and confidentiality interests of the office of the president can be addressed through the White House's assertion of executive privilege on a document by document basis. So again, we have a plaintiff suing for, DOGE being involved in a way that it shouldn't be involved. And they're saying, well, maybe piece by piece, we might be able to give you a couple of things here. Not a Russian take. No, seriously, that's what I can think of, is it just keeps going, right? Anywho, that's how a very famous attorney, that's how he would describe the court system. He's like, it's like a Russian tank. It's not fast, but it's destructive. Oh my gosh, the district court's order flouts these principles at every turn. Rather than allowing discovery as a last resort, the court entered its discovery order at the very outset of the case, before any motion for preliminary injunction and before resolving the government's motion to dismiss, which could obviate the need for discovery altogether or substantially narrow it. And here we go. So moreover, as the government explained below, discovery is irrelevant to the court's resolution of the plaintiff's claims. Oh my gosh, everyone. Let's just double check which claims we're talking about here, everyone, since I'm going to need to be able to cite this so that I can laugh properly. Oh, here we go. Let me just make sure. Pull the, all right. Let me just make sure. 1 second, everybody. Let me just pull up this file. I want to make sure I've got it. 25, 50, 72. 25, 50, 72. Right. Right. So we've got. All right. This is originally coming from. Let me see here. Where are we coming from exactly? Okay, we're appealed out of 00429. State of New Mexico v. Musk. So this is, I've forgotten the name, everybody. This is that giant lawsuit that had been filed by all of those states. They're just referring to it as New Mexico, but that's where this is coming from. All right, so it's kind of a sidetrack interlocutory situation. Right. So he's going up against, a dozen attorney generals in this situation. All right, here we go. Now he's saying again, we have, it's irrelevant, right? In order to resolve the claims, plaintiffs allege a violation in the Appointments Clause and the USDS's statutory authority on the theory that USDS and Mr. Musk are directing decision-making by agency office holders. Those claims present pure questions of law that can be resolved and rejected on the basis of plaintiff's complaint. Will that be a motion for summary judgment? Perhaps, but you still need to have enough information. Oh dear. In particular, precedent establishes that the Appointments Clause turns on proper appointment of office holders. It's not concerned with the de facto influence over those who hold office. I don't know. That's a lot of... I don't know about that one. And plaintiffs' statutory claims can likewise be rejected based on the text of the statutes. and applicable doctrine, taking their allegations as true. Indeed, the district court recognized that these claims present legal issues appropriate for resolution after fulsome briefing. But rather than await such briefing, the court charged ahead with discovery into the functioning of the White House and the president's senior advisors. I don't know about that one. The district court brushed aside the White House's concerns that the plaintiffs were seeking privileged information, the disclosure of which would threaten core functions of the office of the president. The court did so on the ground that the White House could protect its interest by asserting the privilege on a case-by-case basis. That is precisely the reasoning the Supreme Court rejected in Cheney. And the threat to the executive branch's interest is substantial here. Plaintiffs' vaguely worded requests, which the district court largely allowed, burdened the White House with the task of identifying and assessing privileges for a significant amount of sensitive material, much of which would both be privileged and entirely irrelevant to the claims alleged. So let's pause here for a minute, because I just want to remember when, Jack Smith was going through giving discovery in the Florida case and in the DC case. There was all of that discovery, and so Mr. Trump was like, boo-hoo, I don't have time to read it all. Boo-hoo, boo-hoo, boo-hoo. And, Jack Smith was like, I have given all of it to you. It's been tabbed, it's been ordered, everything's in, been carefully presented. So all you have to do is open your eyeballs and look at it. And so now they're like, oh, it's too much of a burden for us to tell you why we created this agency that you're claiming is illegal under the law. It's like, we think you set it up fraudulently, incorrectly, illegally. And so we need your paperwork. Sometimes this just cracks me up, everybody. Seriously. They're suing under a statute because they're saying, you didn't have the authority to set this organization up, and we want some paperwork. They're like, we don't want to have to give it to you. All right. Fine, then we won't do any of that. Oh my goodness. All right, the district court's discovery order was improper and warrants this court's exercise of its mandamus authority. Talk about hitting a fly with a hammer instead of a fly swatter to prevent the grave threat to separation of powers principles that the order poses. Sometimes I wonder if they play like the, big crescendo music that you hear, like the fight, like men fighting, or before they go into the battlefield with like the drums or whatever. They're playing that while they write this so they can be inspired, because this is crazy. Mandamus is asking the court to order someone to do something. So they're ordering a government person to do a particular task. So here's footnote number 1. Plaintiffs oppose this petition and request for a stay. All right. Well, that's nice that they can. Rocky music. Thank you, Anthony. Oh my gosh, I really needed the help with that one, Anthony. I appreciate it. Exactly. So we've got the Rocky music going. We're running up the stairs in Philly. We're like, all right. So it's all very, very important, and a big, big whoop-de-doo-dah here. Call each other, and I don't know. They may do, well, hopefully they're not on Signal, first of all. Second, we talk with our peers that we work with, right? We talk to other attorneys, even if they are opposing counsel, and the judges and clerks. It's a community that you're in because you're seeing the same people day after day after day. So I wouldn't be surprised one bit for these judges to be like, can you even believe this? But in a way that's anonymous enough to make sure that it's ethical. I'm sure. I'm sure they do it that way. All right, here we go. Statement. Oh my gosh. Executive Order 14,158 of just this, this administration establishes USDS as an entity in the executive office of the president. All right. The order states that USDS is led by the USDS administrator, who reports to the White House Chief of Staff. The USDS helps carry out the work of modernizing federal technology and software to maximize governmental efficiency and productivity. The order also establishes the U.S. DOGE Service Temporary Organization as a temporary organization within the DOGE service under 5 U.S.C. Section 3161, also led by the, is it led by everybody? The USDS administrator, that's right. Oh my gosh. And the order requires USDS to coordinate with DOGE teams within federal agencies and composed of employees of those agencies to achieve efficiency goals. Executive Order 14,210 establishes a workforce optimization initiative to eliminate waste, bloat, and insularity within the government. Among other things, the order directs agency heads to prepare plans regarding certain hiring decisions in consultation with the DOGE team leads. Now, I've not heard a lot about hiring. Has anyone heard about any hiring? Oh my gosh. All right. Agency heads to prepare plans regarding certain hiring decisions in consultation with the DOGE teams. So I've got a couple things to say. First of all, no one's getting hired, everyone's getting fired. And second of all, I think this is one of the loyalty questions, right? Do you know what you're doing? No. But are you loyal? Yes. Like, all right then. The order also requires the USDS administrator to submit a report to the president regarding implementation of this order. And this, my friends, is that moment where the micromanagement that is Mr. Trump's signature comes in. So he's supposed to be getting a letter explaining or a report regarding how all of these orders are being implemented. And, you know, what are the chances that he's reading it? Including a recommendation as to whether any of its provisions should be extended, modified, or terminated. Again, delegating executive order information out to the agencies. Right? Are you following me on that? So he signed the executive order, and then the people in the agency are supposed to report back on whether or not to extend different pieces, keep it, or let it go. But this is an executive order, right? He can't read. Well, you know, I just don't even know anymore. I don't know. Oh my gosh, I just don't. The parties agree that defendant Elon Musk does not occupy an office of the United States and does not hold formal authority to exercise the powers of any such office. So let's highlight that, because he is filing this stinking motion for mandamus or writ of mandamus in his official capacity. And now he's saying there's no formal authority. So that confuses me. I'm absolutely confused here. Elon Musk in his official capacity, and then over here, Elon Musk does not occupy an office of the United States, does not hold formal authority to exercise the powers of any such office. Like, isn't the power of the office to ask for a writ of mandamus? I mean, come on. Oh my gosh, it's driving me crazy. All right. Instead, I gotta bring it back down again, everybody. Bringing it back down. Instead, Mr. Musk, a close presidential advisor, is a special government employee. He certainly is special. He certainly is. Which is defined by statute as an officer or employee of the executive or legislative branch of the United States government who's retained, designated, appointed, or employed to perform temporary duties for a limited time period allowed by statute. Again, if you're only going to be performing temporary duties, can you file a writ of mandamus? That's a good question. The answer is no. They're wondering. A little sassy tonight, everybody. I tell you what, this weekend with the protests, got a little sass going on. A collection of states brought this suit against the USDS. The USDS temporary organization and Mr. Musk and the president in their official capacities. Plaintiffs allege that Mr. Musk is serving in violation of the Appointments Clause and that the USDS and the USDS temporary organization have exceeded their statutory authority by directing significant actions taken by agency office holders, such as terminations of employees, contracts, or grants. Plaintiffs allege that defendants' actions could affect federal funding and that the states receive or could have downstream consequences that will indirectly lead to the states to expend more funds on various services than they otherwise would have. Spoiler, that's happening on everything. Just, in case you're wondering. In case you're wondering about that, based on these theories, plaintiffs moved for a temporary restraining order on February 14th, seeking to restrict the defendants' activities and require disclosures. Now, we don't know, again, if that's actually, what the purpose was. The district court denied the TRO on the ground the plaintiffs had not shown irreparable harm. Remember, Judge Chutkin came out with her decision, and she said, can you be a bit more specific, please? Only the possibility of harm. The court also noted this court's holding that at least certain appointments clause violations are not, without more, an injury that necessitates preliminary injunctive relief. Citing for the case law there. Yes, there was a lot of people. Even in my little tiny blue dot, there were a lot of people. Shortly afterwards, plaintiff filed an expedited motion seeking broad discovery in support of still forthcoming preliminary injunction motions. This, by the way, is happening quite a bit in a lot of the cases against the administration. So just if you see this term, expedited briefing, and it's saying, let's move this up instead of having the normal, 90-day ping pong that we do back and forth. Like you have 90 days, then you have 90 days, then you have 90 days. And so it takes, 2 years to get one set of interrogatories finished. So they're wanting to move this quicker than the regular process. So here's the plaintiff's request. This is what they want in their discovery. A production of all documents, including those that defendants have created, compiled, or edited relating to defendants' involvement in data access, employee interviews, or terminations of grants, contracts, or employees within any agency. Production of all documents about USDS's future plans expressly for the purpose of allowing plaintiffs to seek emergency relief before any such action takes place, which, is good. C, broad interrogatories about the USDS's personnel structure in relationship to agencies, including the names of all USDS personnel and the names of all agencies as to which DOGE personnel have recommended various actions or accessed systems. And D, a request for admissions of various allegations, such as that USDS or Mr. Musk directed various actions. Well, that's true. We're always asking for admissions. It doesn't mean you have to admit it, but we're going to ask you because sometimes people just do admit it, and that makes our job easier. The government opposed on the grounds that discovery against the office of the president and the president's close advisors is extraordinary, and that the requested discovery was unnecessary, overbroad, burdensome, and likely to implicate privileges. The government also explained that the court should consider other options before permitting plaintiffs to take discovery, including prioritizing a decision on purely legal questions that could resolve or narrow the case. All right, so here's my question to the chat, everybody. We're going to start doing some review questions because nobody asked for that. So according here to what he's saying, well, he didn't draft this, but to what the government's saying is that they would have to go through this process of sorting out privileges. So I went through and read what they're looking for. They're looking for documents. They're going to be asking interrogatories, which are questions. And then they're talking about they want to have plans and so forth. So would that information that they're requesting, would that be covered by the immunity decision made by SCOTUS this past summer regarding presidential immunity? Yes or no? Yes or no? Are these documents, is this discovery privileged in a way that's covered by the Trump case this last summer? All right, that's the question. That's the question. No, it's not privileged. No, it's not privileged. Okay, no. Okay, so then part 2, because this is the law, we have to have multiple parts. Part 2 is, why not? Why isn't this discovery covered by that immunity? Okay, no. Okay, good. No, right. But why not? Why can't he use presidential immunity from that case in order to say that this is privileged, you can't have that information? Okay, so let's look at what we've got here. Okay, unless Elon's confirmed, so let me write this down. All right, so Elon would need to be confirmed, temporary employee. Okay, improperly formed, improper form. Okay. Elon's not the president. That's true. Not president. Not part of defined in constitutional duties. Okay, constitutional duties, that's a good one. Duties. Okay, a DOGE is not included in that immunity. Well, right, but why? Why? Elon isn't an official position. Okay, right. So he's I think that, yeah, he's not confirmed. We'll do confirmed and official here, so you know what I'm talking about. Right. So those are the suggestions. Any other ones on why this discovery wouldn't be included, wouldn't be protected by that presidential immunity created, and they would be privy to the information? Okay. Says he doesn't have anything to do with DOGE. All right, so nothing to do with it, nothing to do. And agency, Congress, right? Congressional agency. All right. So here's the okay, not asking for any communications and notes, only about actions and recommendations. Okay. All right, good. So we've got a pretty good list here, everybody, and I love it. I love how we're processing this. And the reason I asked this question is to remind everybody that the case this summer for immunity only applies to criminal cases. All right. Oh, I know. So the presidential immunity set out in that Supreme Court case is not usable in a civil case because that standard is only in criminal cases. Huh? See what I did there? Wow, I know, right? But that's the thing. You got to start shifting that in your mind. You have to start moving that around and saying, all right, this absolute immunity, we're talking about official jobs that he's doing and how is it written? Is it covered? Is it not covered? But the first question that you should be asking is it a criminal case? All right? Is it a criminal case? That's what you should be asking first. All right? So just as a little reminder, everybody, oh my gosh. All right. So it has to be criminal. This is not criminal. Now the civil case, that's a different story. Civil immunity, we can look through Nixon for that, but U.S. v. Nixon as well as the Fitzgerald case. But when we're talking about this immunity case here, we have to remember that this is going to be a criminal question, right? So when they're talking about immunity, or when they're talking about having to implicate privileges, like what kind of privileges are they talking about too? So they also need to get that, they have to get that sorted out too before they start pleading it out. Right, had a sneaker coming, I know. Well, I know, right? I mean, that's one of the hardest things to really, wrap our minds around is that this is just for criminal actions. All right, so we'll keep going forward here. Of these cases help with impeachment process since they're civil cases? It's possible. Absolutely, it's possible. The rules of evidence are a little bit different with regards to impeachment. Like there really aren't that many, if any at all, really. So yeah, I mean, outside information could absolutely be brought in. But can immunity be used in a criminal case if he knowingly did it? That is, if he can prove that intent. So that's the thing. What's the act? Knowingly did what? Like what would be the center? What would be the crime itself that would be charged? Long time started this semester with a question about a case with a tricky answer. No, that's bad, professor, bad. Oh my gosh. Well, it's you gotta have fun with your students, everybody. Right? All right. So let me dive in. We'll kind of let's chew on this a little bit. We'll let it cook a little bit. Whole semester, anybody could get it right. I know. All right, soon thereafter, knowingly that he knew that his creation of this was, a violation of the law, and he did it anyway. Very difficult. Very difficult to prove. We're in the land of treason then, right? Very, very difficult to prove. If he ordered the taking out of the political, right, I think that would be a clearer cut situation. Kea would be if that was more specific, as opposed to, I think we can recreate or we can use a previous committee in order to put a different committee into place to do some stuff, right? So the intent element as well as the act are difficult to bring a criminal case. Soon thereafter, the government moved to dismiss the claims in their entirety, arguing that taking plaintiffs' allegations as true, the claims failed for lack of standing and on the merits. The government also requested to consolidate the preliminary injunction proceedings with the merits under Federal Rule of Civil Procedure 65A2. The district court granted plaintiffs' expedited discovery requests nearly in full. The district court recognized that discovery into the executive, particularly the White House and senior advisors, imposes a heightened burden requiring careful consideration, and that the Supreme Court has instructed that the executive's constitutional responsibilities and status are factors counseling judicial deference and restraint in the conduct of litigation against it, including the timing and scope of discovery. Again, with this Cheney case, the court also recognized that a preliminary injunction motion was not yet pending and noted as prior conclusion that plaintiffs had failed to show irreparable harm. Nonetheless, the court held that the possibility of expeditious resolution of this case outweighed the burden of discovery on the executive branch, which the court concluded was a neutral factor. Applying a reasonableness approach used in ordinary cases, the court reasoned that discovery is inherently burdensome. Duh. And rejected the government's separation of powers concerns, reasoning that the White House could protect its interests by asserting privileges on a case-by-case basis. The court also decided that it would not extend the heightened consideration afforded to senior members of the executive branch to USDS because it believed USDS might wield substantial authority independent of the president. And although all agree that Mr. Musk is a close presidential advisor within the White House, the court stated that the discovery burden was lower because defendants claim that Musk does not lead DOGE. So, of course, then we have this question of what exactly it is that Mr. Musk does with DOGE, right? Oh, you're so sweet, Boxer Mom. Oh, that's so sweet. Possible with the whole, I know, right? Anything right now, it feels like the parameters of reality have been, shaken or shook. So I can understand that. As to breadth, the court rejected the government's concerns that the discovery requests were overbroad and unnecessary, stating that the numerous requested categories of documents and interrogatories were reasonable, narrowly tailored, and necessary to resolve plaintiffs' forthcoming preliminary injunction motion. In the court's view, the burdens on the government were also lower for various other reasons. Because USDS has existed less than 2 months and the request did not cover electronic communications. Now, with this as a side note, one of the things that has hit the news, the community, is that DOGE doesn't have a FOIA office as of the last time I looked at their website. So the Freedom of Information Act has to have a point person for all federal agencies. So you would send your FOIA request into that person, and then they go through it and look through it. But DOGE, because it's, not really up and running properly or put together properly, did not have the appropriate FOIA point person either. So it was kind of a mess. Can you actually lie in court papers? No, Cynthia. Well, let me step it back. As an attorney, I cannot ethically lie. I have to have candor to the court. So that means I cannot lie in any filings whatsoever. But if someone who's not an attorney is, writing stuff, they're not going to lose their law license if they lie. But attorneys are not supposed to lie. You could get called out for it. Your credibility could get shot. Your reputation could be over. Hello, John. Welcome. And you could have your license, held for a while. They're like, I'll just take your license for 2 weeks or until the end of class, until you apologize. So that's really it. They have no intention of honoring any FOIA requests. So I'm glad you that's kind of what we're talking about here, because they're not playing around. I just went through, redid, I don't know, what do we have, like maybe 12, 15 DOGE lawsuits, and one of them, the name escapes me because they all blend together. But in one of them, one of the pieces was you need to comply with our FOIA requests. And so that goes hand in hand with discovery and can have an order compelling discovery and FOIA attached to it if the government continues to refuse. So now we're actually in a situation where the court has the jurisdiction to start enforcing when they're telling them to do that. And people are starting to be more likely to be in trouble. Aren't they trying to close FOIA up? Yeah. If it's federal, and of any assistance whatsoever to anybody, yeah, they're trying to. Seems like these attorneys don't have the same. They don't, Cynthia. And I can say that ethically, because we're not supposed to say negative things about anyone in our profession or the profession itself without facts and evidence to support what we're saying. So yes, you're correct. There's a lot of unethical attorneys filing this stuff here. Right. Oh my goodness. In finding discovery to be necessary, the court declined to address the government's pending arguments that the discovery was irrelevant to the resolution of plaintiffs' claims. The court acknowledged that the government had made standing and merits arguments that could obviate the need for discovery, or at least reduce it, including in a pending motion to dismiss. But the court stated without elaboration that it was not convinced that the government's arguments raised legal issues appropriate for resolution after fulsome briefing. Again, this is just with regards to the restraining order, all right? So I'd say we've got about 2/3 of the cases have been, restraining orders have been granted, but about 1/3 have not. Although acknowledging that it would benefit from briefing on the issue, the court nonetheless authorized discovery in the interim. The court also recognized the unusual timing of discovery before resolution of a motion to dismiss or the filing of a preliminary injunction supports defendants, but the court concluded that it need not wait to conduct discovery because the court had decided, per the government's request, to consolidate preliminary injunction proceedings with the merits. And the court stated that the absence of a preliminary injunction motion was a technical issue of little consequence because plaintiffs had sought the TRO, which had already been denied. So I think that's actually a decent point too. So she had already said your restraining order, you don't have enough to meet the test for the restraining order. You failed the restraining order test. And if you can't meet the restraining order test, you will probably fail the injunction test. Although, we don't know, but it's possible. The court doesn't have to explain why it wants discovery. True story. True. The court's order thus adopted the language of plaintiffs' discovery demands largely in full. But the court clarified that discovery did not apply to the president, limited discovery to matters that involve or engage with plaintiff states, including entities and institutions operated or funded by plaintiff states, and held that discovery into Mr. Musk's actions would be limited to documents regarding his direction of actions rather than mere recommendations. So she was tailoring that discovery request a bit more. Hello, Kristen. Welcome. Good to see you. Good to see you. The court also changed the production deadline from the 7 days requested by the plaintiffs to 21 days, and the court denied a request for depositions, though it warned that if defendants fail to adequately respond to plaintiffs' written discovery, plaintiffs may renew their request for depositions. Ooh, everybody. All right, everyone knows what a deposition is? I'm just double checking before we start talking about how amazing that would be. I mean, that would just really, that would make this whole situation so much more interesting. Everyone, so interrogatories are written questions, and you're limited to a certain number depending on what the rules are. So the rules will tell you can have, like, I'm just making a number up, I don't know what they are in DC, but you can have 20 interrogatories. And then if you need more, you can do a special request. You can ask for supplemental interrogatories and get like another 5 questions. And when I say questions, I mean, 5 pages is one question. I mean, when you're drafting interrogatories, which nobody does, you just tweak what's already out there, but you just try to make the question as multi-parted as you can. So you're basically asking 20 questions with one question, but that's the nature of the beast. Anyway, those are interrogatories. But when we do depositions, that's when we have a court reporter show up and we do just a question answer situation with someone under oath. All right. So depositions are great because you can print that out and use that during trial when the witness starts to just lie. You can also cite to it multiple times if they are changing their story in pleadings. And I would have to say depositions are going to be an element of kryptonite for Mr. Trump. They always have been, they always will be. Anytime any of these cases, any of these people get under oath and have to testify under oath, that's going to be like a huge hit to the administration because they don't do well. They don't do well. That's why if we would have discovery, that would be amazing. The other reason why too, for those of you that have been hanging out in the JGG case, right? So that's the El Salvador case. They had a hearing a couple of days ago and there was some discussion about, well, we could brief this stuff a little bit more. And the judge said, well, we might need to have hearings. And then the government was like, oh no, well, we don't want to do that. And the reason you don't want to do that is because now all of your people are under oath and they have to answer questions or they can go directly to jail. So it's kind of a big deal. Same with depositions. So again, this would definitely be one of those pieces of kryptonite for the Mr. Trump. I know I'm all over the place. I'm always talking about Batman. I get it. But tonight we're going to deal with kryptonite. So work with me here, people. Oh my gosh. All right. Lastly, the court denied the government's request for a stay of any discovery order so that the government could consider emergency relief. And then we get into the argument here. So I'll just summarize here. We'll skip through this argument just a bit. I'm not going to read word for word because I do have some other documents I just wanted to kind of show you and talk about a little bit too while we continue through our journey tonight. So first argument, the court should exercise its mandamus authority to block the discovery order against the White House defendants. Now, this is a little weird because they're saying you want to issue a writ of mandamus. So what they would be doing then would be commanding the lower court it would be a mandamus again is you're telling someone to do something. So they'd be saying to Judge Chutkin, you need to rescind your discovery order. That's what they'd be asking here. That'd be so weird. So, I mean, that's kind of a weird way of going about this. I don't know. Again, you don't need to mandamus everything, but whatever. The Supreme Court has made it clear discovery against the office of the president is reserved for exceptional circumstances and must be a last resort. I don't know that they have, but, whatever. At least that's some kind of a legal argument. B, discovery order here directly contravenes Cheney and violates separation of power principles. Like, all right, well, again, could be seen as at least a legal argument, so we like that. District court improperly ignored the constitutional burdens and separation of powers concerns that discovery against the office of president raises. That's their next piece. It's like the writ that never ends here. Okay, keep going. Here we go. And okay, I have a lot to say about that one. The requested discoveries are relevant to deciding plaintiff's claims. This is one of my favorite things when they tell the judge, well, you don't really need that. You don't really need to know that information. You've got enough. Like, well, we don't. And, you know, it's not really your job to tell us, but whatever. Oh my gosh, some of these arguments and filings are just almost too much, everybody, almost. All right, district court failed to consider alternatives that would avoid discovery. I'm not sure what an alternative would be. I mean, you ask them, like, how did you do this in order to figure out if what they did was illegal? I mean, oh my gosh, all right, we're moving through. We're coming to the end here, everyone. I do like a nice conclusion. So here we go. Here's our conclusion. We'll see how good this conclusion is. How'd we do? In short, the district court's discovery order flouts well-established principles governing litigation against the office of the president. It gives short shrift to the substantial separation of powers concerns that plaintiffs' discovery requests raises, instead treating plaintiffs' requests as if they were a garden variety discovery matter. Because the government has no alternative means for remedying the court's clear violation of established law and the significant intrusion on the functioning of the executive branch that it represents, Mandamus is warranted. See, this language they're like even acknowledging that what they're doing is just ridiculous. And I'm trying to think to myself, like, you know, if a district court judge is setting parameters for discovery, like you can appeal questions that have been asked that could be harmful, that you don't have a right to hear. You can, put objections in during depositions or on interrogatories. But this idea of even asking for that information, they're saying the judge can't even ask for discovery in a legal civil case. Like that would be completely opposite of what we do in litigation. It doesn't make any sense. They want another judge to tell this judge that she can't have any discovery, even though she's the judge on the case. It's like, well, that's not how that works, really. Indeed, the generic appointments clause in ultra vires allegations at issue based on arguments that presidential advisors de facto directed agency decisions could proliferate across a multitude of contexts involving challenges to agency action. The court should make clear that discovery into the office of the president is reserved for exceptional cases. So instead of, again, this isn't even an appeal. They didn't even appeal her order. They could have they could have tried at least to appeal her discovery order. Instead of appealing and trying to go through the interlocutory appeal process, they file this piece of rubbish, which is a petition for a writ of Mandamus or Mandamus here. So they're going to the Court of Appeals and they're saying, you need to tell Judge Chutkin that she can't have discovery. Like, what are you doing? No. I know. At what point does the judge just complete? Right. Well, I mean, we're starting to get there, I think. We're starting to get there. But, in order to be a judge, you have to have a lot of tolerance just to start, or at least be able to hide your intolerance enough to be able to do your job. So there you go. That's fascinating. Again, this was filed just a couple weeks ago. And as I was trying to put this case back up on the docket, this is such a crazy situation. I was getting my banana stickers out. I'm like, the only thing you can really call this is absolutely bananas. This just doesn't make any sense. This is crazy talk. It's what it is. That's just not how that works. Like, hello. That's a bit frustrating. All right, let's take a look and see what else I've got here on my desk. It's bananas, right? I mean, that's just like, oh my gosh. You know, be inventive. Use something new. Do something cool. Like, oh, I never thought about doing it that way. Or instead, just do something that's so stupid. It's like, oh, that's stupid. That's not going to help anybody. All right. All right, let me take a look here through my stuff. Did anybody see that they are recommending like 85 months prison for George Santos in New York? Did anyone see that? I read that and I thought, I don't know. I mean, you can do what you want, but dang, that's a lot of time. But it was a lot of money, and there was a lot of harm that was done. So I don't know. Just don't see those kinds of numbers these days. When it's a fraud case, we don't see those numbers. Yikes! But maybe we should. Yes. It just came in. The AG was like, yeah, he's a big liar. We don't like that. I'm like, I don't know about that. All right, just FYI, this is the case that came from, everyone. So if you're wondering what that DC case is with Judge Chutkan and the multiple states, that's the et al. Here. This is the case. Let me move my hand in case you want to do a screenshot. There. So there's that. That's so crazy. All right, what else do I have here? American Federation of Labor and Congress of Industrial Organizations versus Department of Labor. This is the motion to compel, everybody. Oh, I'm so glad I put this together. My today, right now me, thanks my prior me. Can a judge recommend a lawyer be disbarred? A judge, anybody with a law license anybody can make an ethics complaint. Anybody can make an ethics complaint. It's just if you have a law license, you have an obligation to report. We're basically mandatory reporters for ethics violations in the legal field. Now, how we choose to go about that, we could argue, but the judges definitely can say, one thing or another. But if a case is not in front of them, they're not going to make a recommendation to disbar. If that is the long way of answering your question. We'll just go around the road a few times before I get to the point. Apparently that's how we're doing things. All right, let's take a look here. This is really short, but this is our first order to compel discovery, everyone. All right, this is a different case, so keep that in mind. But I wanted to just read a couple of paragraphs here because they're going to walk us through what the government's done and how they have not complied. And that's why the judge is ordering this compelling discovery. The motion to dismiss on the one because Trump told labor not to acknowledge the government unions. Yeah, there's several. There's three, actually. Three collective bargaining cases running right now. And there's a lot of crazy stuff going on in these cases. Like I haven't seen much of this before. Okay, so this is an order to compel discovery. It usually shouldn't. Well, if you file a motion to compel, that's really where it needs to stop. If you can get one motion, maybe sometimes two motions, but if you're in a situation where you get an order put into place, you're in trouble. And this is interesting how the timing is set up on this particular situation. So it's not the end of the world, but it's an interesting situation. They're saying to the government, you need to give the information to the other side. Jack's cases ever be revived? Yes, it can. Yep, they can. They were dismissed without prejudice. Filed in the Kennedy Center. No, not yet. Not yet. But, anything could happen anymore. Here we go. Before the court is plaintiff's motion to compel discovery. The motion turns on the interpretation of a definition in the limited expedited discovery that the court previously approves. Now, again, expedited discovery was ordered. This is a different case. All right, this is a different case. This is not Mr. Musk's case that we just read through. In this order, the court does nothing more than interpret that definition. It neither expands nor narrows the scope of the discovery the court has already approved twice over. Again, request for discovery and then a motion to compel discovery. So the judge is like, look, I've told you twice already. In the end, the court grants plaintiff's motion to the extent it is consistent with the court's interpretation of the definition the court previously approved. In late February, the court granted plaintiff's motion for limited expedited discovery, and the court denied defendant's motion for reconsideration and slightly modified the limited discovery earlier this month. And then we've got footnote 1. The court did not modify the definition that is subject of this order. Defendants have not taken any further action to challenge to the limited discovery since before this court or otherwise. Much of the limited discovery rests on the definition of DOGE employee, a definition that plaintiffs proposed with their initial motion for expedited discovery, and the court subsequently approved. Flip this. That definition reads, quote, DOGE employee refers to any individual who is employed by DOGE or otherwise works for DOGE, including volunteers if any, including any individual employed by DOGE but detailed to one or more federal agencies. In plaintiff's view, the definition encompasses members of the DOGE team at the defendant agencies who were onboarded to the federal government after January 19th of 2025. Defendants read the definition differently, contending that it reaches only to individuals who have an employment relationship with USDS. USDS direct hire or a person who volunteers directly with USDS. So defendants have not produced any discovery relating to individuals without such a relationship, and plaintiffs now ask the court to compel them to. Yikes! As parties recognize, the resolution of plaintiff's motion rests on the meaning of or otherwise works for DOGE in the definition. It's evident whom this phrase does not include those employed by DOGE. Footnote 2. Consistent with defendant's argument that individuals detailed to an agency are employed by the agency, and seemingly consistent with the discovery they have thus far produced, the court concludes that individuals employed by DOGE include direct hires and other federal agencies who are detailed to USDS. Here, and we're citing further case law. And elsewise, the phrase would do no work. Also evident is one group that falls within the phrases reach volunteers. When someone says that a volunteer works for an entity, it's understood that the volunteer is not formally employed by the entity, but that he still does work on behalf of the entity. And then he cites a dictionary. I love when judges cite dictionaries. They're like, according to the Webster, like, all right, well, that's important. Hold on here, let me make sure I'm in frame. As a result, or otherwise works for DOGE covers individuals who work on behalf of DOGE but are not formally employed by the USDS. So, I mean, they're talking about Elon Musk, right? Those who work on behalf of DOGE in turn include all individuals that defendant agencies have onboarded to implement the DOGE agenda, including those that the agencies have hired directly or through detail agreements. This is clear for two reasons. To start, the DOGE executive order reveals that the individuals implementing the president's DOGE agenda at an agency do not simply work on behalf of the agency, but also on behalf of DOGE. The executive order directs agency heads to select the individuals to implement the DOGE agenda in consultation with the USDS administrator and requires the agencies to coordinate the DOGE teams' work with DOGE. Next, the record shows that the individuals implementing the president's DOGE agenda at the agency defendants included individuals directly hired by each agency, regardless of whether they are also directly hired by DOGE, as well as individuals detailed to each agency, whether the USDS or elsewhere. Defendants' declarations and briefing both before and after plaintiff's initial proposed discovery have explicitly and repeatedly said as much. So let me fast forward a little bit here. So we've got the basic idea of what he's talking about when we're talking about defining who all was involved. So let's see exactly what the judge is ordering here. Tea break. Okay. My office chair's rolling around here. Ordered that plaintiff's motion to compel discovery is granted to the extent consistent with this order. It's further ordered that in light of the delay, the disagreement about the definition of DOGE employee has caused the discovery shall be extended until April 8th. So 2 days from now, and the preliminary injunction briefing schedule shall be amended as follows. Plaintiffs shall file their preliminary injunction motion no later than April 15th. The defendant shall respond to the preliminary injunction motion by no later than April 22nd. And plaintiffs shall file their reply to defendant's response to the preliminary injunction motion no later than April 25th. And it's so ordered on March 31st. So it's really nice when we can actually get a schedule put together. This is how I'm changing up the closet docket right now, as I'm doing it according to what's been ordered and what dates things are due. So there you have it. They've said to the government, like, give them what they want. And you kind of stalled things out. So they set up another way of, another timeline here. Wake up tomorrow and the penguins are in charge of the country. We all hope that. That's funny. All right, next, here we go. We've got the Pickering, Hale, and Dorr LLP case. Oh, the reason I pulled this out, oh my gosh, everybody. Okay, I remember why. I just basically printed out a whole bunch of stuff. I was like, I gotta show everybody this stuff. So this is the docket for one of the cases involving the executive order that's kind of bad-mouthing the law firms, right? This particular one I wanted to show you, this is the docket, and you can tell the difference between a regular lawsuit and a lawsuit where the lawyers are like really mad about the situation. You can tell just by looking at this. So we have our complaint that was filed on the 28th, perfectly normal, right? So in the complaint, you put down here, here's the attachments. We've got some exhibits and some summons. We got to make sure the information gets to the right people. And then it's like, look at all the summons. Oh my goodness. Look at that. Then we have exhibit A, B, cover sheet, and then a summons here. And look at all these attachments and summonses. This is crazy town is what this is. This is not normal to see this. On a regular, and then there's more over here. A regular lawsuit. This is not normal. This is what happens when you go after lawyers. They're like, all right, we're going to do this. Let's do this. Rolling up the sleeves like it's paperwork time now. It cracks me up. Oh my gosh, it cracks me up. Oh my goodness. Well, you got to laugh, right? You got to laugh at something. So, oh my gosh. Now, the other part here that's really interesting is then we have on the 28th, so the same day, we have a minute order, so it's paperless, right? We've kind of talked about that before. It's kind of that quick answer that the judge will put into the docket, not a real order, but I mean, it's a legit legal order, but it's not like a decision, like a memorandum and an opinion, right? So it's real quick. Sometimes they'll just put in like, I'm denying it, 1, 2, 3, 4, 5, and then it's the end, right? So here they've got, upon consideration of plaintiff's complaint in this case, which was directly rather than randomly assigned to the undersigned judge. So again, this lawsuit was specifically given to this judge. The court concludes plaintiff's notice of related case, indicating that this case is related to the 2 other cases brought by different plaintiffs against similar federal government defendants, the Perkins case and the Jenner Block case, which case was also filed today and also directed to be assigned, is erroneous. Since these cases are not related. So they said we're not going to consolidate it. But then, and this is what's so interesting, right? So here's your minute order. That looks familiar to everybody, right? That's not the end of the order. Look at this. This is so crazy. This whole page. That's not normal. That's absolutely weird to do that. This minute order should have been here and then done. But instead, it's like 2-point font down in here, and like Hillary Clinton's brought up. Like, there's so much. It's just showing how our courts are like, oh my gosh, this is just crazy town. We're in crazy town. So anyway, they're going through and explaining everything. This is the court again. Yeah, none of this is normal, right? Something like this is usually like an order. Like you would have an electronic document that you would file. But instead, you've got the judge, like basically this is a sticky note for the judge. But it's a big sticky note, like what's happening there? Oh my gosh. So anyway, they're just going through the rest of it here. We've got a minute entry for a hearing that was set on the 28th, and then transcripts were ordered. But again, this huge, look at this, joint status report by all of these departments. Oh my gosh. Here's the minute order right here. That's normal. This right here is normal. All right. This is normal. But this is not normal. Oh goodness. So that's what happens when law firms are like, well, we're gonna be doing some of this now. We're not here, we're not playing around. All right, so I had that to share with everyone because it just cracks me up. Next in my stack, oh yeah. So this just came out, U.S. Supreme Court, right? Right, that's not, well, right, exactly. Like, that's not right. So this was the decision made by the U.S. Supreme Court regarding the Department of Education in California. So California had filed a suit because of grants, teacher grant money that was frozen, right? So it had been allocated by Congress as it's supposed to, but it hadn't been dispersed, right? So this case went all the way up to the U.S. Supreme Court because it's a really big deal. This is one of the earliest cases that was filed too. It's a per curiam case. We don't know who actually wrote it, but we do know that we've got dissents. And Kagan dissented, Jackson dissented, and I'm gonna look here. I think Jackson's dissent was really well written, and she's not playing around. She's pretty angry about it, and I can't blame her. And then, right, so we have 2 dissents, and then we don't know who wrote the opinion. So it's 3 paragraphs. So I wanted to read it just to make sure everybody knows what happened, because this just came out. All right, so this is the teacher money case. And here we go. On March 10th of 2025, the U.S. District Court for the District of Massachusetts issued what it styled as a temporary restraining order enjoining the government from terminating various education-related grants. The order also requires the government to pay out past due grant obligations and to continue paying obligations as they accrue. The district court's conclusion rested on a finding that respondents are likely to succeed on the merits of their claims under the Administrative Procedure Act. On March 26th, the government filed this application to vacate the district court's March 10th order as extended on March 24th and requested an immediate administrative stay. The application was presented to Justice Jackson and by her referred to the court. Although the courts of appeals generally lack appellate jurisdiction over appeals from TROs, which is a huge issue, everyone. This is one of the biggest issues that we're going to see, is how much appellate jurisdiction is there over a temporary restraining order. All right, this is huge. Several factors counsel in favor of construing the district court's order as an appealable preliminary injunction. So what they're saying is because we're not sure exactly how our appellate review works for TRO, what we're going to do is we're going to change it into something that's not a TRO. We're going to change it into a preliminary injunction. Even though it's called a restraining order, we're going to call it a preliminary injunction because that is reviewable. we do have appellate jurisdiction over that. So we'll just, change the name. All right. Among other considerations, the district court's order carries many of the hallmarks of a preliminary injunction. So again, this is a situation where the Supreme Court's like, well, let's just change what it's called, and then we will just, do this differently. I mean, this kind of stuff kind of rubs me the wrong way, you know what I'm saying? Because if it's a temporary restraining order, it's a temporary restraining order. There's a test. You pass the test, you get the TRO. And there's a preliminary injunction test. You pass that test, you get a preliminary injunction. So just because the court's like, well, your restraining order is kind of like, it has the essence of a preliminary injunction, which would give us the authority to hear the appeal. So let's just turn it into that. It's like we don't have magic wands here on the Supreme Court. You know what I'm saying? So this drives me a little bit bonkers. Moreover, the district court's basis for issuing the order is strongly challenged, as the government is likely to succeed in showing the district court lacked jurisdiction to order the payment of money under the APA. So now the Supreme Court is saying the government's likely to succeed. We didn't have that situation below in the lower courts. The APA's waiver of sovereign immunity does not apply if any other statute that grants consent to suit expressly or impliedly forbids the relief which is sought. Nor does the waiver apply to claims seeking money damages. True, a district court's jurisdiction is not barred by the possibility that an order setting aside an agency's action may result in the disbursement of funds. But as we've recognized, the APA's limited waiver of immunity does not extend to orders to enforce a contractual obligation to pay money along the lines of what the district court ordered here. So basically they're saying, we don't think that the district court should have ordered them to pay money. They overstepped. As for the remaining state factors, again, respondents have not refuted the government's representation that it's unlikely to recover the grant funds once they are disbursed. No grantee promised to return withdrawn funds should its grant termination be reinstated, which I think is a cheap shot too, everybody. They're saying, well, even if you try to give us the funds, because these are donated funds, a lot of them, and the people that put the money into the grants, that put the funds in there, aren't going to take their money out because their money's not being spent how they're supposed to spend it. So they're like, well, you're not really getting hurt. And the district court declined to impose a bond. By contrast, the government compellingly argues that respondents would not suffer irreparable harm while the TRO is stayed. Respondents have represented in this litigation that they have the financial wherewithal to keep their programs running. So they said, so long as you can scrape by with your programs, then you don't really need the money. So if respondents ultimately prevail, they can recover any wrongfully withheld funds through suit in an appropriate forum. And if respondents instead decline to keep the programs operating, then any ensuing irreparable harm would be of their own making, which I think is really crappy. Such self-imposed costs are not properly the subject of inquiry on a motion for a stay. We construe the application as seeking a stay pending appeal and grant the application. The March 10th order and March 24th extension of the United States District Court for the District of Massachusetts is stayed pending the disposition of the appeal in the United States Court of Appeals for the First Circuit and disposition of a petition for writ of certiorari, if such writ is timely sought. Should certiorari be denied, the stay shall terminate automatically. In the event certiorari is granted, the stay shall terminate upon the sending down of the judgment of this court. It's so ordered. And look at what we have right here. The Chief Justice would deny the application. What? I'd have to say my best guess is that I think Kavanaugh wrote this. But the Chief Justice and the other dissenting judges here were like, you're out of your minds. District was just told they're I know. It's just, it's atrocious. Yeah, it was already promised. Exactly. Exactly. So we do have a dissent from Justice Kagan. So we do know that she didn't write the opinion. And I'll just do a couple sentences here. It is a mistake for the court to grant this emergency application. Nowhere in its papers does the government defend the legality of canceling the education grants at issue here. On contra, the per curiam, the respondent states, have consistently represented that the loss of these grants will force them, indeed already has forced them, to curtail teacher training programs. The remaining issue is whether this suit brought under the Administrative Procedure Act belongs in an ordinary district court or the Court of Federal Claims. So that's her point, and an excellent point it is at that. And then we have Justice Jackson, this is Justice Kagan here, and then Justice Jackson, and she's got some stuff to say. She wrote this, Justice Sotomayor joined her. So again, this is just another dissenting opinion on why she believes that the decision was improperly done. And then she goes through like how this actually is quite harmful. Like not getting grant money, I mean, of course it's going to be harmful. Like who doesn't need the grant money? I mean, if it's a school, if we're talking about, well, maybe Meta doesn't need the grant money. Like, oh, Zuckerberg, we're not going to give you your grant money. And he's like, I don't care. I'm going to space with X. And that Amazon guy, you know, they don't care. But you've got a school here. You have a school and you have teachers and you have needs. They come down out of your ivory towers for a minute, everybody. All right, and so here we go at the very end, and I think the last couple paragraphs of Justice Jackson's dissent are incredibly powerful, so I will go ahead and read through this as kind of our final piece here. So finally, even if this were a close case, the Hollingsworth case, the balance of the equities clearly counsels against staying the TRO and reinstating the grant terminations. On one side of the balance, the government assertions of harm of if the TRO remains in place amount to speculation and hyperbole, as the First Circuit put it. On the other hand, there is ample evidence that the loss of grants during the remaining days of the TRO period will inflict significant harm on the plaintiff states and their instrumentalities. Those harms are concrete. In Massachusetts, Boston Public Schools has already had to fire multiple full-time employees due to its loss of grant funding. In New Jersey, the College of New Jersey has canceled the remainder of its teacher residency program for the same reason. In Illinois, Chicago, hold on, I'm flipped. Public schools, which have already faced a multi-million-dollar budget deficit, may have to shut down its successful teacher pipeline program. In California, California State University has ended support for the 26 students currently enrolled in its teacher residency program and has eliminated financial assistance for about 50 incoming students. I mean, it's just awful. And she goes on. This court's eagerness to insert itself into this early stage of ongoing litigation over the lawfulness of the department's actions, even when doing so facilitates the infliction of significant harms on the plaintiff states, and even though the government has not bothered to press any argument that the department's harm-causing conduct is lawful, is equal parts unprincipled and unfortunate, is also entirely unwarranted. We do not ordinarily exercise jurisdiction over TROs, and this one is no different. So again, she's saying, like, I'm not going to flip this around and call it an injunction. It's not. It's a TRO. The government has not articulated any concrete harm it will suffer if the grant terminations are not implemented in the next 3 days. And this court will have every opportunity to address all the legal issues the government has hastily shoved up the chain of review and more in due course, because we could have and should have easily denied this application. I respectfully dissent. Whoa! So she's a little spicy there. Spicy Justice Jackson. Can't blame her one bit. I know. She's got some spice to her. She's so incredibly well spoken. In a way that people can actually understand what she's saying, that it's just like a breath of fresh air every time I read. I wish it had not been a dissent. I wish he could have written a majority opinion that they agreed on, but such is life, the way that it goes. Yes, and Justice Sotomayor then agreed with the dissent, so she joined her on the dissent. And let's just, oops, that's not it. Let me just, where did I put it? Nope, I don't know where I put it. Just a minute. Oh, here we go. Here's the puppet. So this is Justice Jackson here. Justice Jackson, very well spoken, has great questions during oral arguments. We love her. Oh my gosh. All right, everybody. Well, that's kind of it for my stack of paperwork to take y'all through for tonight. I see. Well, yes, I think, again, you just don't know which way she's going to swing every time, but there's definitely potential there. About her to get more. Oh, I know. Oh, you're welcome, Charles. I'm so glad you could come by. So again, everyone, just a friendly reminder, I will be here on the tube on Sunday, Tuesday, Thursday nights, 7 p.m. Central. And if we've got any like breaking orders or anything that comes down, like I'm waiting on the JGG order for the court, because that's going to be a contempt order. And I'm like, what's going to happen? So with the things that are happening right away, the breaking news, those I will be over on the talk since it's still up and running, but I will consistently be here. So Sunday, Tuesdays, and Thursdays at 7. So whatever I've done that has been breaking news over on the talk will go through over here in a more leisurely manner. So nothing better than a visual aid. Right. And I have my friend James Madison hanging out with me right now. I really needed James Madison quite a bit lately. I'm like, sir, thanks for writing what you wrote, but we're kind of in a bit of a mess. Do you mind? So this is my go-to hero right now. So with that, thank you everyone for joining me tonight. This was so much fun. As always, thank you to the moderators for your hard work. I appreciate you all so much. I'll go ahead and sign off for tonight, but I will be over on TikTok to do a live if anything is like breaking news. So for the orders that just come down, if I think it's super important, then I will go ahead and go live over there. But I will make sure for any of those that I post them up here, and I will be consistently over here Sunday, Tuesdays, and Thursdays. So I'll be back again on Tuesday, everyone. Have a great rest of your night. Thanks again for coming by.